Welcome to Think About It with your host, Jaden Miller.
Good day, and thank you for joining me on my podcast, Think About It with Jaden Miller. Hope you guys are doing well. Before I begin, please like, share, and subscribe on my YouTube channel, and like, comment, and follow on your favorite podcast platform. As I've mentioned, I'm on Spotify, Apple Podcasts, Spreaker, Google Podcasts, Castbox, SoundCloud, iHeartRadio, and many more. So, as I've shared with you all in the near past, I finally kind of found the niche that I wanted to take this podcast. And because I am retired from law enforcement and I am an educator, I decided to center my podcast around something that I really like talking about, and that's American government and economics, which I did teach at the high school level, and criminal justice issues that I taught at the college level. So today I'm going to get into one decision by the United States Supreme Court, which many people find as the worst decision ever rendered by the United States Supreme Court. And that case is called the Dred Scott decision. And it's formally Dred Scott versus John Sandford. All right. It's a legal case in which the United States Supreme Court on March 6, 1857 ruled 7-2 that a slave, that would have been Dred Scott, who had resided in a free state and territory where slavery was prohibited, was not thereby entitled to his freedom, that African Americans were not and could never be citizens of the United States, and that the Missouri Compromise of 1820, which had declared free all territories west of Missouri and north of latitude 36 degrees 30, was unconstitutional. The decision added fuel to the sectional controversy and pushed the country closer to civil war. When we look at the Dred Scott case, we have to ask a question. Okay. That question is, was Dred Scott free or a slave? And I'm going to get into that in just a moment. Dred Scott was a slave in Missouri. From 1833 to 1843, he resided in Illinois, which was a free state, and in the Louisiana Territory, where slavery was forbidden by the Missouri Compromise of 1820. After returning to Missouri, Scott filed suit in Missouri court for his freedom, claiming that his residence in free territory made him a free man. After losing, Scott brought a new suit in federal court. Scott's master maintained that no Negro or descendant of slaves could be a citizen in the sense of Article 3 of the Constitution. Again, the question is, was Dred Scott free or a slave? All right. So let's get into some of the meat in this. Dred Scott was a slave who was owned by John Emerson of Missouri. In 1833, Emerson undertook a series of moves as part of his service in the United States military. So what Emerson did was he took Dred Scott is the slave, from Missouri, which was a slave state, as I mentioned, to Illinois, which is a free state, or was a free state, and finally into the Wisconsin Territory. Again, free territory. All right. Now, during this period, Scott met and married Harriet Robinson, who became part of the Emerson household. Now, Harriet Robinson was a slave as well. All right. Emerson married in 1838, and in the early 1840s, he and his wife returned with the Scotts, the slaves, to Missouri, where Emerson died in 1843. Now, Dred Scott reportedly attempted to purchase his freedom because slaves could do that. Okay, if you had enough money, you could actually buy your freedom. All right. So Dred Scott attempted to buy his freedom from Emerson's wife. However, she refused the sale. So in 1846, with the help of anti-slavery lawyers, and you should know that even prior to the Civil War, there were a number of people in the North who were against slavery. They were abolitionists. All right. And so they always had this sense that, in the United States, a country that fought to have its freedom from Great Britain, which was not enslaving the colonists, at least not the white colonists, but the actions of King George III and Parliament were very tyrannical. They were, taxing heavily, and, they were engaging in all kinds of uncivil behavior towards the colonists, jailing them, killing them, raping their wives. All kinds of things were going on at the behest of, King George III and Parliament, because Parliament was powerful in Great Britain. And a lot of people think that King has all the power, that he has this autocratic rule, but not in Great Britain. And that's a topic that I'll have to get into another time. King George III certainly had power as the king, of Great Britain, king of England. All right. But Parliament also was somewhat powerful too. Now, mind you, they certainly listened to the king. All right. But the Parliament had power. And so it wasn't just King George III, barking orders from across the pond. Parliament was allowing a lot of this stuff that was going on in the 13 original colonies to happen. But the original point is that there are many abolitionists and many people that lived in the now United States in the 1800s that were against slavery. All right. And so Dred Scott and his wife Harriet had a number of supporters. They could not read. Dred Scott could not read. Harriet Scott could not read. And that's not unusual. A lot of slaves, actually in many areas, slaves were forbidden to be taught how to read. Okay. So they needed other people to help them. All right. Now, Harriet and Dred Scott filed individual lawsuits for their freedom in Missouri State Court in St. Louis on the grounds that their residence in a free state and a free territory had freed them from the bonds of slavery. It was later agreed that only Dred's case would move forward. The decision in that case would apply to Harriet's case as well. All right. Now, although the case was long thought to have been unusual, historians later demonstrated that several hundred suits for freedom were filed by or on behalf of slaves in the decades before the Civil War. And I don't doubt that. There were a lot of slaves that had been moved from slave territory into free territory and who had support amongst anti-slavery lawyers or abolitionists to seek their freedom. And so, of course, they were filing suits in courts. All right. Now, the Dred Scott versus Emerson case took years to be resolved. All right. But in 1850, the state court declared Scott free. All right. So he first won his freedom in the district, in which he filed the suit in Missouri. All right. However, so now for almost 2 years, Dred Scott is free. All right. But the verdict was reversed in 1852 by the Missouri Supreme Court. All right. So the Missouri Supreme Court invalidated Missouri's longstanding doctrine of once free, always free. All right. The Missouri Supreme Court did that. And that was the law at the time. All right. Once free, always free. All right. So then, as a result of the decision by the Missouri Supreme Court, Dred Scott is now back in slavery. All right. So now, Emerson's widow, all right, this is the woman now that is also actually the owners of Harriet and Dred Scott, then left Missouri and gave control of her late husband's estate to her brother, John Sandford. All right, so that's why the case is Scott versus Sandford, okay? And he was a resident of New York State, all right? But because Sandford was not subject to suit in Missouri, Dred Scott's lawyers filed a suit against him in United States District Court. All right. So this was the United States Federal Court, the District Court. All right. And they found in Sandford's favor. All right. So now Dred Scott is still a slave. All right, because the the district court, United States District Court, found in Sandford's favor. All right. Now, the case eventually reaches the United States Supreme Court. So now, this is a 7-year ordeal for Dred Scott. Okay. So the case reaches the United States Supreme Court, and its decision was reached in 1857. All right. So now, you have to understand the time and the makeup of the court. All right. There were 9 members of the Supreme Court. Okay. And remember now, we're talking about the 1800s, the mid 1800s, just prior to the Civil War. All right. And of course, a number of the members of the Supreme Court are pro-slavery. All right. Some of them are from the southern states. All right. But there's one in particular that we need to talk about. His name was Chief Justice Roger Brooke Taney. All right. Chief Justice Roger Brooke Taney. All right. Now, the consensus is that Taney's opinion for the court was arguably the worst he ever wrote, coming after the fact that, or coming before the fact that, this is considered to be the worst decision ever rendered by the United States Supreme Court. And let's talk about why that is. First, Roger Taney ignored precedent. He distorted history and then imposed a rigid rather than a flexible construction on the Constitution, and he ignored specific grants of power in the Constitution and tortured meanings out of other more obscure clauses. All right. What he's trying to do is he's trying to correct a political decision by using the courts. All right. And that was frowned upon. All right. So his logic on the citizenship issue was perhaps the most convoluted. All right. Now, he admitted, Roger Taney, Chief Justice Roger Taney of the Supreme Court, he admitted that African Americans could be citizens of a particular state and that they might even be able to vote, as they in fact did in some states. And actually, they were able to vote in 5 states. Now, let me stop there for a minute because you need to understand this portion of it. Okay. So remember, we have a federal government. And then we have state governments. All right. Well, the states have their own constitutions and they have their own laws. All right. And the federal government, while it is the supreme government in the United States, states have rights. All right. And so while African Americans, were not considered citizens of the United States, and some states, a particular state could admit or could have or legally state, that African Americans were citizens. All right. And some states did. All right. Not all of the states were following in line with southern states or with the federal government. All right. So in Taney's opinion, while he admits that African Americans could be citizens of a particular state and that they might even be able to vote, as they did, as I mentioned, in at least 5 states, he argued that state citizenship had nothing to do with national citizenship and that African Americans could not sue in federal court because they could not be citizens of the United States. Oh, what a funky rationale. Let's look at this. All right. He says that Dred Scott's suit, therefore, should have been dismissed for lack of jurisdiction by the district court. All right. Now, the district court had already found in favor of Sandford. Okay. But Taney is now, throwing shade on the district court. All right. And on this point, Taney stood on shaky constitutional ground. If even one state considered an African American a citizen, then the Constitution required that all states, and by inference, also the federal government, had to accord that person all privileges and immunities of citizens in the several states, which includes the right to sue in federal court. And then also Article 3, which establishes the jurisdiction of the federal courts, does not mention national citizenship, but rather declares that the judicial power shall extend, among other things, to controversies between citizens of different states. This is the so-called diversity jurisdiction, all right? Now, even with this weak argument, Taney could have been accused of nothing worse than faulty reasoning if he had stopped there. If Scott was not a United States citizen, he could not sue in federal court, and the case would therefore have been improvidently granted. But Taney was determined to impose a judicial solution on the slavery controversy because, again, we're working up towards the Civil War. All right. Now, although later courts would adopt the policy of deciding constitutional questions on the narrowest possible grounds, the pre-Civil War courts often decided all issues that could support their rulings. Thus, Taney continued holding that Scott had never been free, and that Congress had in fact exceeded its authority in the Missouri Compromise because it had no power to forbid or abolish slavery in the territories. Now, you've got to know a little something about the Missouri Compromise. All right. It had already been an issue that had been settled. All right. The Missouri Compromise has served as the accepted constitutional settlement for nearly 4 decades. And according to him, it failed. All right. Even the doctrine of popular sovereignty, as articulated in the Kansas-Nebraska Act of 1854, where the people of each federal territory would have the power to decide whether the territory would enter the Union as a free or a slave state, according to Taney, lacked constitutional legitimacy. So again, what this guy is doing is he's saying that Congress exceeded its authority, but more than anything, Taney is exceeding his authority. What is the role of the judicial branch? It is to interpret the law. It is not to legislate, and it is not to take executive actions. But it seems to me, and it seemed to others, of course, that this is exactly what Chief Justice Taney is doing. Okay, so in essence, he voided the principles of free soil, opposition to slavery in the territories and in newly admitted states, territorial sovereignty, and indeed every aspect of anti-slavery constitutional thought. Now, regarding the question of Scott's freedom, Chief Justice Taney held that Scott could not claim to be free on the basis of his residence in Illinois or Wisconsin. Whatever status Scott might have had, according to Taney, while in a free state or territory, he argued, once he had returned to Missouri, his status depended entirely on local law, notwithstanding the doctrine of once free, always free. So again, Chief Justice Taney is simply not holding on to or going along with precedent. Something had already been established, all right, in previous cases by the Supreme Court. Precedent is important. All right. So he would have been on reasonably strong ground had he limited himself to upholding the district court's decision based on the idea that status was to be determined by the states. I'll do that for you again in case you missed it. He, meaning Chief Justice Taney, would have been on reasonably strong ground had he limited himself to upholding the district court's decision. The district court had already decided in Sandford's favor. All right. But Also, he could have held that Scott was not entitled to sue Sandford in federal court on the basis of diversity of jurisdiction, which I just mentioned, because Missouri did not allow even free African Americans to be citizens. But Taney outraged much of the North by asserting that African Americans could never be citizens of the United States. All right. He said that the framers, the founding fathers of the Constitution, in his view, did not regard African Americans as being among the people for whose benefit and protection the new government was founded, notwithstanding the perfectly general language of the Declaration of Independence and of the preamble to the Constitution. What gall, what unmitigated gall. All right. Now, there were two justices on the United States Supreme Court back then. One was John McLean of Ohio, and then there was Benjamin Curtis of Massachusetts. And they wrote devastating critiques of Taney's opinion. Curtis, in particular, that's Justice Curtis, Associate Justice of the Supreme Court Curtis, particularly undercut most of Taney's historical arguments, showing that African Americans had voted in a number of states at the founding of the country. And he stated, at the time of the ratification of the Articles of Confederation, they were members of the nation and could not now be denied the right to claim citizenship. All right? That's what he said. He argued that they were members of the nation and could not now be denied the right to claim citizenship. All right? Now, of course, there is a great loving of this ruling in the South. All right. So one Georgia newspaper stated, the Southern opinion upon the subject of Southern slavery is now the supreme law of the land. Okay. And opposition to it is morally treason against the government. That's what they said in a Georgia newspaper back during this time. So now the view that Southern ideologues such as John C. Calhoun, now you know John C. Calhoun was a senator, all right, and he was definitely pro-slavery, and he had promoted this idea for more than a decade, that the federal government had a positive and indeed a constitutional obligation to defend slavery. Now, according to this decision by Taney, had triumphed. And of course, in the North, it exploded in denunciations of Taney's opinion. All right. Several sober appraisals in the Northern press decimated the Chief Justice's tortured legal reasoning. The Republican, this is a newspaper from the North, editor Horace Greeley published Justice Curtis's dissent as a pamphlet to be used in the elections of 1858 and 1860. All right. The press during that time and the pulpit echoed with attacks on the decision that were heated as Southern defenses of it. Just as heated as Southern defense of it. Now, Chief Justice Taney's hopes of selling the issue lay smashed. If anything, the Dred Scott versus Sandford decision inflamed passions and brought the Union even closer to dissolving. All right. Now, for all practical purpose, Northern courts and politicians rejected Scott versus Sandford as binding. In an advisory opinion, Maine, the state of Maine, their high court declared that African Americans could in both state and federal elections. The Ohio Supreme Court ruled that any slave coming into the state with his master's consent, even as a sojourner, became free and could not be re-enslaved upon entering to a slave state. The New York Court of Appeals handed down a similar ruling in Lemon versus the People in 1860. In several states, legislatures resolved to prohibit slavery in any form from crossing onto their soil and enacted legislation freeing slaves passing within their borders. All right. Now, let's talk about Chief Justice Taney for a minute, because he is now remembered solely for this blatantly pro-slavery decision he wrote and for his demeaning comments about African Americans. When he died in 1864, he was roundly denounced and vilified in the North. There was a Republican Senator, Charles Sumner of Massachusetts, that predicted that the name Chief Justice Taney is to be hooted down the pages of history. Whatever else he may have done, his name will always be linked with that of a slave who wanted nothing more than his freedom. Now, Dred Scott did, in fact, get his freedom, okay, but not through the courts. After he and his wife, remember Harriet, were later bought by the Blow family. Now, the Blow family are the family that originally owned Dred Scott. Okay, they sold Dred Scott to Emerson. Okay, now the Blow family were able to purchase Dred Scott back and his wife, and they freed them. All right, now Dred Scott unfortunately did not live very long after his freedom. All right, he died of tuberculosis in St. Louis the year after the Dred Scott decision, all right, and after he was freed, all right. His wife, Harriet Scott, lived until June 1876. She was alive long enough to see the Civil War and the 13th Amendment, which abolished slavery in the United States. And in fact, she was even around to see the 14th Amendment, which I'll talk about in a minute. So that's the basis of it. That's the Dred Scott decision. The majority on the court held that a Negro whose ancestors were imported into the United States and sold as slaves, whether enslaved or free, could not be an American citizen and therefore did not have standing to sue in federal court. Because the court lacked jurisdiction, Taney dismissed the case on procedural grounds, as I've already mentioned. All right. So this was a 7-2 decision. All right. As I mentioned, Chief Justice Taney was able to get 6 of his cohorts to agree with his decision. And then there were 2 dissenters. That was Benjamin Curtis and John McLean that dissented and tore apart Chief Justice Taney's argument. All right. So, what came about after the Dred Scott decision? Well, of course, there is the Civil War that began in 1861. That really, of course, divided the nation. Dred Scott's decision outraged abolitionists. They saw the Supreme Court's ruling as a way to stop debate about slavery in the territories. So the divide between North and South over slavery grew and culminated in the secession of Southern states from the Union and the creation of the Confederate States of America. All right. Now, Abraham Lincoln's Emancipation Proclamation of September 22nd, 1862, freed enslaved people living in the Confederacy. All right. Now, of course, there's always been some controversy surrounding that. Well, if the Confederate States are their own nation, how does Abraham Lincoln's Emancipation Proclamation free slaves that live in the Confederacy? But that's a topic for another time. But it would be another 3 years until Congress passed the 13th Amendment abolishing slavery in the United States. Now, the 13th Amendment is real simple. All right. It says neither slavery nor involuntary servitude, except as a punishment from crime whereof the party shall have been duly convicted, shall exist within the United States or any place subject to their jurisdiction. All right. And Congress has the power to enforce this article by appropriate legislation. All right. It's very simple. All right. Slavery is abolished in the United States. All right. It cannot be slavery or involuntary servitude, which is what they called it when, whites were involved in that type of thing. It is not acceptable anywhere in the United States, all right, except as punishment for a crime where there has been due process of law, all right? And it's not the slavery that we through history know, mostly where you have black people that are on plantations and they're either chained or there's an overseer riding around on a horse and they're being whipped and told what to do and what to say and what not to say and that kind of thing. You know what I mean? Prison, that's due process. You can be made to work while you're in prison, all right? But you're in prison because you've been given due process of law, all right? Now, the issue of whether or not an African American is a citizen or not was finally settled, all right? It wasn't settled by the 13th Amendment. The 13th Amendment simply freed the slaves and stated that no one else in the United States could be held in slavery or involuntary servitude. All right. So the question still begs. Now you have all of these freed black people. All right. But what are they? So if we go back to the Dred Scott decision, Chief Justice Taney, who decided to be a legislator or a dictator as opposed to one who interprets the law, had decided that, regardless of what states say, that no African American can be a citizen of a state, nor can they be citizens of the United States. All right. He wiped out elements of the Missouri Compromise, and failed to acknowledge that, especially in the state of Missouri, that, once you're free, always freed, So it wasn't until 1868, with the advent of the 14th Amendment, where this issue of whether or not a person is a citizen, when I say person, I'm talking about someone of African American descent, is a slave or is a citizen or even person. All right. This was settled then in 1868. So remember now, during the time of right after the Civil War, African Americans are freed, by the 13th Amendment. But who are they? Is the question. What are they? What is their legal standing in the United States? All right. And again, it is not until a few years later when the 14th Amendment is ratified, and it simply states, and I want you to be clear that the 14th Amendment was written, at least Section 1 specifically, was written, for freed African Americans. That was the original intent and purpose of the 14th Amendment, Section 1. All right. And it says all persons born or naturalized in the United States. OK, so that first part of the 14th Amendment establishes that if you were born in the United States and you happen to be African American, you are a person. It first establishes that, because remember, African Americans that were slaves were not persons. They were property. There's a difference between being a person and being property. All right. So the 14th Amendment now establishes at the federal level. Remember, there are some states that did not consider African Americans as property, specifically in the North. All right. But the federal government made this now the law of the entire land. States are now subject to it. And I'll go on. So now we understand that at the federal level and at the state level, African Americans are persons. Let's go on to the next part. It says, and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside. So now, with that one sentence, African Americans are considered to be persons and citizens of the United States and And that's a key word. That little word "and" is so big, okay? And of the state wherein they reside. So you are a citizen of the United States and a citizen of the state wherein you reside. So if you are a resident of Georgia, you are a citizen of Georgia and you are a citizen of the United States. The 14th Amendment lays that out. It goes on to say, okay, and again, all this does, the 14th Amendment, it certainly wipes out, well, the 13th Amendment did too, Chief Justice Taney's argument that no African American can be a citizen of a state or of the United States. That was, now, of course, Chief Justice Taney had died in 1864 and the South had lost the Civil War, okay? But there's a part of me that wishes that he could have still been alive just to be able to see, how his faulty Dred Scott ruling, is finally now wiped away clean by Congress. All right. So the next sentence in the 14th Amendment says, no state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States. Now, we would have to go back into the Constitution. OK. All right. Where it states, OK, that people in states, especially in those states that considered African American citizens, gave them the right to vote, okay, that they have privileges and immunities like citizens of that state because they were citizens of that state. All right. So no state now shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States. There's another word that's very important. It's nor. And that comes in the next part of this. It says, nor shall any state deprive any person of life, liberty, or property. Remember now, nor shall any state deprive any person. Okay, so now remember, African Americans are now persons now of life, liberty, or property without due process of law. Okay, and then finally it says, nor deny to any person within its jurisdiction. Remember, persons, these are African Americans. The 14th Amendment section 1 is written specifically at the time for African Americans. All right, it says that nor deny to any person within its jurisdiction. We're talking about the states. Okay, the federal government has already established, okay, that all persons born in the United States and subject to its jurisdiction are citizens of the United States. That is settled in the first sentence. All right. But then we have to talk about these states because remember, states have rights. OK, but the federal government has now told the states no, nor. OK, it's very simple. It says no state and nor shall any state. OK, nor deny to any person. OK, so nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny to any person within its jurisdiction the equal protection of the laws. That means equal protection. The laws are supposed to be equally applied, okay, to everyone. All right. Everyone. This is the 14th Amendment. This is 1868. Now, of course, we know, and we can talk about this in another episode, was this always applied specifically after, there was some hooliganism going on in Congress and, within the Republican Party at the time to get a certain person elected. And I'll talk about that at another time. But so, of course, Reconstruction during this time had changed, okay? And so now not all persons are equally protected under the law, okay? As we see coming into the Plessy versus Ferguson decision, which I have talked about, so you can check out that episode, and then leading into the 1900s. Of course, there's not equal protection, okay? And of course, there were some states depriving people of life, liberty, and property, specifically black people, okay? All right. But the 14th Amendment specifically at this time in 1868, I'm connecting back to how it destroyed Chief Justice Taney's horrible decision in Dred Scott versus Sandford. All right. So it's just really important that you have a good understanding, of where Chief Justice Taney's decision led. All right. It led us into Civil War. All right. And it led to the 13th Amendment and finally the 14th Amendment, which decided forever that blacks in this country, descendants of slaves, all right, are persons and citizens of the United States and within the within the state wherein they reside. All right. So that's the Dred Scott decision, a horrible decision by the Supreme Court. And also many people says that it was the worst decision ever made by the United States Supreme Court. And this decision served as a stepping stone to the Civil War. All right. So remember to please like, share, and subscribe on my YouTube channel, and like, comment, and follow on your favorite podcast platform. It's always enjoyable to bring these topics to you. As you can tell, I'm very passionate about what I teach, but also very passionate about ensuring that the law is applied equally and that we go back into history and look at how laws were applied, how they came about, and how we are much better today. So again, thank you all for listening. I look forward to you all coming back and checking out my next episode. All right, everybody, have a fabulous rest of your day.
Thank you for listening to Think About It with Jada Miller. Don't forget to like and subscribe to his YouTube channel, and like and follow on your favorite podcast platform.